Welcome to the American Compass podcast. My name is Oren. I'm the chief economist at American Compass. And today on the podcast, we have my former professor and a conservative legal luminary, Jack Goldsmith, the learned hand professor of law at Harvard Law School, one of the leading, frankly, practitioners of the law of executive power, served in the Office of Legal Counsel under George W. Bush, and also a leading scholar on the constitutional questions of what is the executive power, how can and should it be used, and an analyst of contemporary issues. How is it being used today, and what are the legal issues around that? So I really enjoyed talking about it with him. You should also be sure to check out his Substack called Executive Functions, where he gets into that in depth. But you will hear from him in just a moment. Before we get to him, I have to tell you about what's happening at Commonplace this week. A couple of really cool features. One from Brad Pierce on a company called Schweitzer Engineering Laboratories and the way that they've transformed the economy of Pullman, Washington, focusing particularly on electricity infrastructure. Have an essay from the inimitable Mike Lind on the need to rebuild our shipbuilding industry. And David Cowan on Anderl's big bet on America's defense manufacturing. So I guess it is a reindustrialization special week. We should have thought of that in advance and framed it as such. But you are nevertheless the beneficiaries of all that fine work. Go and take a look. And of course, if you are not subscribed to Understanding America, you can still do so for the not limited time rate of $0. New essays on Mondays, roundups on Fridays. Head over to understandingamerica.co. But in the meantime, here is Professor Jack Goldsmith. And Professor Jack Goldsmith, welcome to the podcast.
Thank you for having me, Oren.
I've been instructed to call you Jack, though you will always be Professor Goldsmith of my fine foreign affairs law class. But I think, for our purposes, more importantly, a leading expert and practitioner on the exercise of executive power, which is obviously very much in focus today. Would love to start by just sort of asking you, before we dive into what's going on with the Trump administration now, how you make sense of, how you would encourage others to make sense of what has been going on with executive power for a while now. Is this what the founders envisioned all along, or are we at a high point, a low point, somewhere in between?
I would say that since the founders created a novel institution in Article 2 and in the presidency, they really did create an independent branch of government with broad executive power. People debate this, but I'm not sure the framers really had a concrete idea of what the presidency would become. I would say that we've been on a long-term, 240 some odd year generic trend of expanding executive power. There were screams about it in the 1790s when George Washington started doing things, and there have been screams ever since, and there's been a long term with a few backsteps expansion in executive power, and there are lots of reasons for this we could talk about if you want. In more recent times, in the last 25 years, I would say that executive power has expanded significantly from the baseline of 25 years ago. In different ways, President George W. Bush, the administration I worked in, especially in the national security context, was very aggressive in asserting executive power, including in disregarding congressional statutes. Subsequent administrations have been very aggressive, all of them, in asserting executive power, largely based on statutes, reading statutory authorizations from Congress very imaginatively and aggressively and selectively to expand executive power. So, there was this glitch, there was this pause in the 1970s after Vietnam and Watergate, with a whole bunch of reforms that constrained the presidency and that worked on many dimensions for a while, but we're now in a period of significant expansion.
Yeah, and you described, I think, what's been going on, particularly sort of in relationship to Congress, which strikes me as, by and large, the right way to think about it, and certainly where a lot of the legal analysis focuses. I'm a big Justice Jackson fan. He's my favorite Supreme Court justice, and at least in my mind, it's called the famous Youngstown Steel Framework. I always still find very useful. And what Jackson said in Youngstown was essentially the executive is at the high water mark of his power when acting in furtherance of a congressional directive. He is somewhere in the middle when Congress has not spoken, and he is at the lowest ebb when acting in conflict with it. And I suppose it is a somewhat question-begging formulation insofar as one needs to know what Congress did in fact direct. But it strikes me as at least useful in sort of categorizing the uses of executive power. Is the president just sort of going off and doing something on his own, or is he really trying to act in direct conflict with what either the law says or what Congress has clearly conveyed as its intention? I think that's from the 1940s. Is that still the right way of thinking about it, or have we moved on?
It was from the early 50s, and it was a concurrence in the Youngstown Steel case. It was just a concurrence. Justice Jackson was the only one who signed on to that opinion. But it became hugely influential in the court, and the court adopted it. The majority of the court adopted that framework, starting in the early 1980s in a case called Dames and Moore. And I would say that the framework is very useful for organizing and analyzing executive power, but it's not very helpful with outcomes. And largely for the reasons you say. It turns on the relationship between the exercise of presidential power and what Congress has done. And in almost all of these cases, what Congress has done is contested. There's some contested issue. In the Youngstown case itself, there was disagreement about whether Congress had authorized or been silent or prohibited the action that President Truman took. And the other thing I would say about the framework is at the center of discussions in academic circles and in the executive branch and in the court, but it's not clear how really determinative it is in kind of predicting and specifying outcomes. And let me say one more thing. You said correctly that Justice Jackson thought that the president was at his lowest ebb when the president acts in the face of a congressional restriction or contrary to a congressional command. That is indeed what Jackson said. But the Supreme Court in the last 10 years in two important cases, a case called Zivotofsky and a case called Trump versus United States, has given the president has won in that situation, and the president has won without any sense of deference to what Congress did. So it's not at all that what Jackson envisioned and what the court is doing in that third category are very different things.
Well, and I guess Zivotofsky in particular, I think this must have been the year I was in class. I think we were reading it still as the slip opinion. And what struck me about it, this is the one concerning what gets written on a passport,
Yep.
if I recall. And the other interesting dimension it introduces is what domain are we acting in? That is, that it may be the case, for instance, that the president has much greater discretion in foreign affairs,
Yep.
and Congress can limit it less, whereas in domestic that Congress sort of has the leading role. Trump versus United States, of course, was the presidential immunity case, which is sort of drawing a different set of lines. Which of those do you think are most important? If one is looking at a president saying, okay, what can he really do here? What are the questions you ask yourself first
Yep.
and foremost?
Well, let me answer it this way, and then you can follow up if I don't answer it the right way. So, first of all, foreign affairs versus domestic affairs. So it's from the beginning, it's been thought that the president has more leeway in action, both on his own authority and how we read congressional authorization, and frankly, when he acts in the face of congressional restrictions, that the president turned to the outward world, as Justice Jackson put it in that opinion, and acting abroad and conducting foreign affairs has more leeway vis-a-vis Congress and more expansive powers. And it's always been thought that domestically the situation was entirely different, that the president's powers are more constrained, that we read statutory authorization somewhat more narrowly, and that the president's discretion to disregard federal statutes are narrower. And I think that's a decent description about how constitutional law has operated. I do think that Trump versus United States throws a bit of a monkey wrench in that, because most people have focused on the immunity part of the opinion, the part of the opinion that said that a former president can't be prosecuted for certain official acts. But the really consequential part of that opinion was the part of the opinion that underlay the immunity decision, where the court said that the president had very broad removal powers, broader than they had described them before. And this is in a domestic context in terms of controlling the federal agencies, especially the Justice Department. And also that the president has an exclusive power to investigate and prosecute, which can be very, very expansive, and again, is a domestic power. So my first cut is that traditionally foreign affairs, the president has more leeway, but the president is asserting lots of leeway in domestic affairs lately as well.
Well, and what's striking about both of those two sort of seams, in a sense, the foreign versus domestic and the kind of control of the executive branch, the judicial, well, not the judicial function, the Department of Justice function and so forth, is that these are now, it seems to me, essentially all of the seams on which many contemporary developments are playing out. I mean, you both have trade and immigration as issues that sit right on the seam of is this an international or a domestic question? And then you have a huge number of questions on the domestic side. The control of Justice Department is certainly one. Then we're also seeing when it comes to removal around independent agencies. And then it seems to me also kind of funding and impoundment questions are the one other set that is in focus right now. Where are you where are you focusing your attention? What do you think is either most fascinating about the current moves or most troubling?
So I'm paying attention to all of it. So I just tell you what my thoughts are thus far.
Yeah.
So I mean, I'm paying attention to the whole thing because it's my job to pay attention to the whole thing. Let me just start off with, and tell me when I'm gone on too much and when you want to how you want to divide it up. But I'll just start off.
Well, pick some categories. Start with one, and we'll jump around.
So let's start with the Unitary Executive. The Unitary Executive, which is a term that's been bandied about a lot since January 20th, there's no canonical definition of this thing, but it's basically the idea that the president gets to direct and control the actions of those officials in the executive branch, including the authority to fire officials in the executive branch. And as Trump versus United States put it, the president of the United States is the only person who's a branch of government because Article 2 of the Constitution vests the executive power in the president. And the Trump administration has gone, and there's a lot of support in Supreme Court jurisprudence for a broad conception of this unitary executive idea. And what the Trump administration has been doing has been pushing that envelope very aggressively. And they're doing so not necessarily in the teeth of the Supreme Court decisions, but going beyond what the Supreme Court has authorized. So this is about the independent agency executive order that basically says, sorry, independent agencies are not independent. The president has full control. The president can fire heads of independent agencies, as the president's been doing. The president can insist that independent agencies bring their regulations before the Office of Management and Budget, which can approve or disapprove. All executive branch agencies have to follow White House interpretations of the law and the like. So that is, I think, the defining legal thing that the Trump administration has been doing. They've been doing a lot of other things, but maybe we can just start there. Do you want me to keep going, or do you want to pause there for a second?
No, that's a great one, and I think one of the things that's interesting about it is that it strikes me as one that is it is not one that has an obvious valence of, oh, this is the sort of pro-democratic, capital D defenders of democracy versus opponents of democracy case. It's one that legal scholars, members of Congress, presidents have been arguing about. I guess you could, in some respects, all the way back to Marbury versus Madison. And so, some of our listeners with a less legal background, just for their reference, we're talking about the distinction, if there is one, between Department of Agriculture, Department of Justice, Department of Commerce, where everyone agrees the president is in charge for the most part. But then things like the Federal Trade Commission, the Federal Communications Commission, the National Labor Relations Board, where Congress has attempted to establish a structure in which the president does not have full authority. And the constitutional question is just, well, is that a thing? Can you have something that isn't part of Congress but isn't under the full authority of the president. And that's a fascinating constitutional question. It's not clear that one versus the other is the sort of more democratic model necessarily.
I agree with you with a caveat. Yes, the existence, with a couple of caveats, the existence of independent agencies, whether they're legitimate or not, this is an old debate. It's an old academic debate going back to at least the New Deal, and frankly even further, but at least the New Deal. And it's been a debate in the courts. And this is an entirely legitimate constitutional debate, and we've seen ebbs and flows on this. And I don't think that the fate of American democracy turns on whether an executive branch agency is independent of the president. So I agree 100% on that. But let me just make two caveats. Something else that's going on, and I'm not sure the fate of American democracy turns on this point either, although on the next one it does. It's not just, you hedged a little bit properly when you talked about agriculture and Justice Department and the president more or less having control. Because there, yes, the president has the power to remove senior officials. But it's not clear how far down the chain into the civil service the president can remove officials. And that's another big issue in this administration. And that is also an implication of the unitary executive, because the unitary executive, pure theory, would say the president can go all the way down and remove the lowest officials. And so that's another fight that's going on. That's a fight that's going on a statutory ground, trying to change how the civil service works. And they're also probably going to be asserting constitutional powers. That, too, is a debate about the unitary executive. That, too, is going on now. That, too, in my judgment, while it's controversial, does not implicate the nature of democracy. But there's a second one that I don't want us to skip over, and that is internal legal constraints on the executive branch. In theory, the president, and in theory and of the Constitution, the president has the authority to interpret the law for all of the executive branch. The president is like the Supreme Court of the executive branch. Now, that is a massive superpower that can easily be abused. And the typical way that the executive branch organizes itself is to decentralize that function to a bunch of semi-independent folks, including in the Justice Department, who interpret the law in good faith with different interpretive principles than courts do, because presidential prerogatives have to be taken into account. But there are real legal constraints on the executive. And this is very important because so many executive actions are governed by law but not subject to judicial review. One concerning thing, in my view, that the Trump administration has been doing is basically eliminating all of those internal checks. They've been through strict loyalty requirements, through firings, through directives, by circumventing even the Justice Department and centering legal interpretation in the White House, not offering any legal opinions for what they're doing. It's pretty clear that there's not a whole lot of internal legal constraint that's being brought to bear, and interpretation and constraint that's being brought to bear on what they've been doing. The extent of this is unclear, but that's the one thing that's the one element of, if you want to call this unitary executive theory, that is troubling from a democratic perspective, because the question is whether the president is subject to law.
Yep. And I guess the question is sort of what is the counterfactual, because you have the piece of paper problem, which is that at the end of the day, if you believe the rest of the points about, even if not the unitary executive, at least the expansive presidential prerogatives, then it presumably is ultimately up to the president, if not to interpret the law himself, to choose the people who are interpreting the law.
I agree. And
so,
sorry, go ahead.
And so so I was just going to say, so I guess there is sort of one objection could be the process objection that you have to have an office of legal counsel, let's say.
I don't believe that.
That's not a requirement. And so I guess the question would be, if we were to say, let's say at the extreme you had a president who simply said, I am going to interpret the law myself as my chief legal advisor, and anyone who has a question about the law means, come to me and I will tell you what I think. That presumably wouldn't be unconstitutional. It would be unwise, and you would have other checks from both somewhat Congress and then the courts. But where in those steps is it that you locate the sort of, is it the prudential concern versus the legal concern?
Okay, this is a great and very hard question. You're absolutely right. And I do believe that the president gets to interpret the law for the executive branch, and the president does not have to be a lawyer. And so what does that mean? Does that mean that there has to be some legal interpretation by the president, or does it mean that whatever the president says goes? I believe that there has to be, that the Constitution requires genuine legal interpretation, but I don't know where or how to draw that line. But I do think that if the theory is the president can do whatever he wants because the president gets to say what the law is, and the president says that whatever he does is the law, is not true to the oath to uphold the Constitution. And let's think about this in the context of the Supreme Court. We clearly think that the Supreme Court, that the justices have jurisdiction to issue final judgments in cases within their jurisdiction. And that means that whatever they say goes in some sense. But if the justices were flipping coins and making decisions that way, would we be saying that they would be upholding their oath? I don't think so. Now, this is a very hard question, and you put your finger on why. Where do you draw the line? How much genuine legal interpretation has to go on? Frankly, we've never confronted these questions on a systematic basis because every president, to my knowledge, has in the round, including Nixon and the first Trump administration, in the round had the model of, in most circumstances, quasi-independent legal interpretation with a genuine effort to comply with the law. So we're in uncharted territory, and you asked exactly the right question, and that's the best answer I can give.
All right. Well, we could spend the whole time on this one, but I want to make sure we do jump around a little bit. Related but separate question, and you mentioned this in the context of the immunity ruling, is the prosecutorial function and Department of Justice, whether it is, U.S. attorneys, prosecutorial discretion. In my list of sort of departments where the president clearly does have authority, Department of Justice has always had a special standing. And so I guess two-part question. Part one, why is that? Is that a tradition or a legal commitment? And then second, what is going on with it now, would you say?
So on the first question, I think it's a constitution. It flows from the Constitution because the president is given the executive power and the president is given the duty to take care to faithfully execute the law. And those are the powers, especially the second one, that the Justice Department is carrying out. Both by statute and by, delegation and custom. So, and this was clear, and the court made this clear in the Trump versus United States case, is that really when the Attorney General acts, he's really exercising the president's executive power and the president's take care duty. And so DOJ has always had this special status as being a reflection of the president's will and therefore under the control of the president. That's as a constitutional matter, with the giant caveat that that is a dangerous thing, and we have since Watergate sought to put norm-based, not legal because it's hard to do, but norm-based constraints on the president's control of the Justice Department. So that's the answer to the first question. There's a special reason why there's a reason why the Justice Department has that special place. What the Trump administration is doing is they're going, as they are in every other context, they're going all in on pure theory, which is to say maximum presidential control of the Justice Department through strict loyalty requirements that all of the top positions in the Justice Department are the president's former lawyers, through directives that insist that there can be no deviation of interpretation, by firings of anyone who has any modicum of perceived disloyalty to the president, and by using the Justice Department to go after the president's enemies, as they've done in a very explicit and overt way. Is any of this illegal? Not obviously so. I mean, maybe selective prosecutions if they end up to that. Is it bad for the rule of law? Yes, it is, to the extent that it deeply politicizes it. Is the Trump administration the first administration to politicize the rule of law? No, it isn't. But is this the most extreme examples we've seen yet? Yes, it is.
And I like that sort of drawing on the take care clause, because it's an interesting way of sort of squaring the circle about the unitary executive. Tell me if this is a fair kind of statement of the argument that essentially yes, the president is vested with the executive power and the duty to take care that the laws are faithfully executed. There are some essentially prerequisite, non-negotiable elements of an executive branch that is in fact accomplishing those things. And so a president, although he has the power, is essentially prima facie in violation of his own power if he hasn't set up certain processes in certain ways. Is that the right gist?
That's one gist,
Yeah.
and I think it's the right gist. But there's a counterpoint, and the counterpoint is, so there are ambiguities, and just tell me if I'm getting too wonky, legal wonky. But there are
We embrace the wonky
Okay,
here on
okay,
the American
okay,
Compass
good.
podcast.
So the take care duty is one of the most mysterious in the Constitution. It, by its terms, says that the president must enforce the law and comply with the law. That's what it means to have a duty to take care to faithfully execute the law. And those sound like constraining principles that would maybe require the president to organize the executive branch in a way that fulfilled those duties. But the take care clause is also the source of what we were talking about earlier, which is the president's power to interpret the law. Because the president can't enforce the law or have his subordinates enforce the law until they know what the law means, so there's this analytically prior power to interpret. And then on top of that, the take care clause is also the basis primarily for enforcement discretion, prosecutorial discretion, for decisions when and whether not to apply the law and under what circumstances. So the Trump administration has been not paying so much attention. I mean, this is crudely put, and I just want to be clear about that. But they have been paying less attention to the aspects of the take care clause that are about strict law compliance, law enforcement, and more on the we can interpret the law the way we want and we can enforce the law with lots of discretion. Again, they're not the first administration to do that, but they are doing it more aggressively than others in my judgment. Does that make sense?
Yeah, I think it definitely does, and it is a good sort of description. I think I started back at the beginning with kind of the Jackson categories that I love. This is sort of another interesting set of categories to think about at any point in time, kind of, how is the dial being turned on each one essentially,
Yeah.
and what are the desirable ranges in which to turn the dials, and then what are the permissible ranges in which
And let me
to
just
turn
say
the
something
dials.
about that. There's no clear answer to that question. And presidents have, all the different dials of the take care clause have been subject to presidential discretion, and different presidents have done it in different ways in different political and legal contexts. We're in an extreme moment now, but variations of these things have always happened before.
So I wanted to ask you about that actually, because thinking about the last 25, 30 years of American history, my read on how we've proceeded through this sort of steady expansion of presidential power is that what we saw in going all the way back to the Clinton administration with Elena Kagan's presidential administration, and then probably more so on the foreign affairs side that you were very involved in with the Bush administration, we saw a lot of essentially pushing the limits of how much power can we find in the laws that Congress has written. And then my sense is that in the Obama administration, we saw, and this is sort of the famous Obama pen and phone comment, we saw almost a shift to more sort of, in essence, what can we do regardless of what the law says that advances our priorities, and Trump then kind of arguably takes that up to 11 in a sense. Do you think there was a discontinuity there that everyone's going to argue about who started it and the other side always started it, but that there's been that sort of phase change?
I would say so. The Obama, what was it, pen and what strategy?
The pen and he has a pen and he has a phone.
Yeah, he has a pen and a phone. But the Obama pen and phone strategy, as I recall, that grew out of the idea that originally he didn't think, I can't even remember what the context was, he didn't think he had statutory authority to do something, and then he did it anyway. But formally, those executive orders, what really happened there was that Obama just took a more aggressive interpretation of what Congress had authorized him to do. And I think that's been the key move. That presidents have, I don't know how far back it goes. I do think one can notice it starting to happen in the Clinton administration, but I'm not blaming anyone or saying it necessarily started there. Elena Kagan's article is a great place to start on all of this. Presidents have, the story goes, and I believe the story, because Congress has not been in the business of legislating to update laws, presidents who are elected to get things done and who feel the political pressure to get things done and to accomplish their agenda have grown more and more aggressive. And we saw this clearly with Obama. We saw this clearly with Trump 1. We saw this clearly with Biden in a whole bunch of circumstances, and now we're seeing it again. More and more aggressive through executive orders and related instruments, relying, pointing to a statute and then invoking constitutional power and saying these things give me the authority to do X, when that legal basis is more and more tenuous. But technically, to go back to the beginning of our conversation, these are still things in Jackson's Category 1. There's still things, or at least most of them are, where the presidents, even Obama, say in the Clean Power Plan, which was very aggressive reading of the Environmental Protection Act, he's still relying on a federal statute. So that has been the trend line. I don't think there was discontinuity in the sense of a different legal theory. It was just more and more aggressive reliance on statutes to do more and more aggressive things.
Yeah, so that's a good point. So I guess the last category I wanted to touch on is the sort of some of the Doge activity and the impounding of funds, potentially wholesale shutting down of agencies. I guess one way of approaching that question would be to say, is that still Category 1 or is that Category 3? But more broadly, where do you see that? Is that, again, another sort of direction we've been headed, or something new in the system?
I think both of these are new in the system and potentially revolutionary presidential power claims. Let me start off by saying that I've had a very hard time figuring out exactly what Doge is doing. So I'm going to speak at a very high level of generality about what they're doing. I've also
the cabinet has as well,
yeah,
so you're not out of the loop.
But I've also had a very hard time figuring out in all of these exactly what the legal arguments are for not spending certain funds and for eliminating agencies and the like. So I'm going to skip over the details and just go to the legal questions.
Yeah.
So impoundment of funds is the idea is that the president has a constitutional authority to not spend appropriated funds. And Richard Nixon invoked that authority. And many presidents in the past have not spent all of appropriated funds. But several things. One, those presidents traditionally have almost always been acting as an interpretation of the discretion given in the appropriation. Point one. Point two, Nixon asserted a real constitutional authority an Article II authority to disregard a congressional command to spend funds over the objection of then Office of Legal Counsel head, a man named William Rehnquist, who was no slouch. But Congress, soon after Nixon asserted this authority, enacted the Impoundment and Control, the Federal Impoundment and Control Act, and basically put statutory constraints on the president's ability to not spend funds. So now, if there's a president, and that has held, and there have been practices that have grown up around that with Congress and the president working things out in their customary practices about these things. But presidents have not asserted a constitutional authority to disregard that statute. That seems to be the claim, the constitutional claim of the Trump administration. President Trump has said that. That is a dramatic assertion, novel assertion of presidential power, because if the president does not have to spend appropriated funds, it basically cuts out, one of the very few remaining powers that Congress actually exercises. So that's a big deal, I think. Shutting down agencies, also similarly a big deal. In the theory of the unitary executive, there's always been a line drawn that the president within the executive branch gets to determine the actions of the executive branch, but that the Congress, under the necessary and proper clause, gets to establish agencies, gets to establish departments, gets to fund them, and gets to tell who has what responsibilities. Now, and within that framework, which even Unitarians have thought Congress had the power to do, that's when the unitary executive kicks in. If they are denying Congress that power, both the combination of the appropriation power and the power to organize the executive branch, then they're really basically killing off two of the main congressional powers vis-a-vis the presidency. Those are huge deals, and I would say they're not small innovations.
All right, well, that's a great segue to our last topic, which is how are we doing? As a nation, as a constitutional system, I think, there is one argument from looking at everything that's going on and saying, this is different, this breaks a norm, this is concerning. There's another view that says the constitutional system is designed for each branch to test the limits of what it can do, ambition countering ambition. The check in place ultimately, for instance, is that the court hears the case and makes a decision. And so long as those processes continue, this is exactly what it's supposed to look like. Where do you land on that spectrum?
So I believe in the basic theory of ambition countering ambition. I'm not sure that the theory works if any particular branch of government, certainly it doesn't work well or easily if any particular branch of government goes all out unconstrained, which is what we're seeing the Trump administration do. But there are countervailing forces typically, even if an administration went all out unconstrained. One typically is Congress. This Congress is not going to constrain this president. It's just not going to, either through formal methods of changing the law or through informal methods, it seems, at least for 2 years, and pushing back on the president. So that basic Article 1 check seems to be missing. The Article 2 internal separation of powers, the constraints I was talking about, that the legal constraints and inspectors general we didn't talk about, and ethics officers we didn't talk about, and the pardon attorney we didn't talk about, all of these friction points within the executive branch eliminated. So there's no check within Article 2 on Article 2. There's no Article 1 check on Article 2. There's the press, and the press is operating. It too is under attack by the president in some unprecedented ways, but it's still able to do its job. But the press usually works in conjunction with politics, and it's not clear how much politics is constraining the president. So that does leave what you said, it's the courts. And the courts are the main, and right now, the only significant check on the president. And we will see what happens. I mean, there are 120 cases right now by last count. There are more than 20 injunctions against Trump's programs. There's been a lot of talk about noncompliance, but my best read is that there have been no actual noncompliance. There's been compliance by the Trump administration with judicial orders. And a lot of these issues are eventually going to be fleshed out in the Supreme Court. We can talk about that if you like. I think the Supreme Court will give the Trump administration some wins and some losses. I think the way the Trump administration is behaving more generally is going to lead it to have fewer wins than it otherwise would. But let me also say, a lot of the things that the executive branch is doing are not subject to judicial review. Arguably, the most lawless thing that the Trump administration has done so far is refusing to enforce the TikTok ban. This was the ban on TikTok, affirmed by the Supreme Court as constitutionally valid. And the Trump administration just decided, well, we just don't feel like enforcing it, and we're going to tell the private companies they don't have to enforce it. That is an extreme interpretation of the Take Care Clause. I would say arguably unprecedented. And there's no case. So it just happened. And so we can't, judicial review, even if it works, won't save us from all of the illegalities. And it never does, by the way. There are always limitations in judicial review that allows the executive branch to get away with unconstitutional actions. It's happened under other administrations. But basically, the courts are the main backstop.
Yeah, we should say technically, I guess it was only for a day, but the Biden administration refused to enforce the TikTok ban first.
Did it refuse to enforce it on that final day? I didn't know that.
Yes, I believe so. We will go back and check to be sure, but and one can question Congress's motivation in setting the day to be the day before the inauguration.
I don't think motivations matter to what the law says. I don't know what the Biden administration did the day before Trump became president. I'm quite confident they didn't tell the private companies. Maybe I'm wrong. We can figure it out when this is over. I don't think they told the private companies it was perfectly fine to disregard the law and keep publishing TikTok. But in any event, whether the Biden administration did it for a day or not, it's not right.
Yeah, and the point is also a good one, that not everything is subject to judicial review. I think the point about the press is also very interesting, because the press, I would at least say the press itself isn't what's important. The premise is that the press is a conveyance of information to the public and a means of sort of allowing that political check to function. And as you said, there's a question to what extent or under which conditions people would actually see something that they are upset about.
Yep, I agree.
And so I guess that would be my last question for you is, as you were watching or as you were advising others what to watch, it's unfair to say what's the one thing to watch for. So what is a one thing to watch for? Is it the non-compliance with a judicial ruling? Is it other things going on sort of behind the scenes?
Yeah, I think the one thing to watch for is the courts on two dimensions. One, what will they do? I mean, I'm very interested to find out what a court that has at least 5 or 6 justices committed to the Unitary Executive, how it's going to respond to what I view as a Frankenstein version of the Unitary Executive, or a distorted and out of control version of the Unitary Executive. Will they uphold it? What elements and the like? And more generally, how the court will respond to the whole program. So yes, the court. And then the second question, of course, is whether the Trump administration will comply. I believe that they will. I believe that they will have all sorts of rhetoric about impeachment and threatening or gaslighting noncompliance. I believe that they will comply. I hope I'm not proven naive on that, but that is my belief. And so there is so much riding on the judiciary in this administration, it really is, I think, the main check on the presidency. And as I said in something I wrote in The Economist a few weeks ago, this is very ironic because it's Trump's people on the court. 3 of them in the middle of the court are on the court. And this is a court that has been attacked viciously by the left for the last 10 years for things it didn't like. And yet this is now an attempt to delegitimize the court. And yet this is now the institution that is the main institution that has a chance to keep Trump accountable to law.
Yeah. Well, for legal wonks in the abstract, an incredibly fun and exciting and interesting time. For the country, an incredibly important and serious time. Professor Jack Goldsmith, thank you so much for talking with us.
Thank you, Oren. That was fun.
And we will be back again soon with another episode of the American Compass podcast.